This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So if you remember, very recently we talked about a case, a Liebowitz case, where Adlife Marketing's case got dismissed because of Leibowitz's failure to prosecute. And if you remember an unrelated Liebowitz case last year with Glenn Craig, we saw that maybe communications between Liebowitz and his clients weren't always what they were supposed to be. So now with that in mind, here's the follow-up with Adlife Marketing. They have filed a brief in support of a motion for reconsideration of the dismissal of the case for failure to prosecute. So they're asking the judge to reconsider that decision. And here's what they have to say. We'll skip all of that. This court made a clear error of fact when it attributed the dilatory and sanctionable conduct of attorney Richard Liebowitz in this and other copyright infringement cases around the country, including his outrageous conduct in Usherson v. Bandshell Artist Management, to Adlife. The court presumed Adlife knew Mr. Leibowitz's abysmal record and was complicit with him. This was incorrect. The facts set forth in the declarations of Adlife's paralegal, Ms. Rebecca Jones, Mr. Joel Abrizio, President and CEO of Adlife, and Mr. Douglas Florent, CFO and Executive Vice President of Adlife, demonstrate that Adlife did not know the things this court presumed Adlife knew. Mr. Liebowitz kept Adlife in the dark about this case and Usherson until it was too late. This court made a clear error of law by not following the requirements of Dunbar v. Triangle Lumber, a Third Circuit 1987 case, which requires a district court, before entering a dismissal or default judgment based on an apparent default on the part of litigants' counsel, to first require the parties seeking the default to plead with particularity and produce supporting material, and thereafter for the court to set a hearing on notice from the clerk of the court mailed directly to the litigant of the time and place of a hearing on any such motion, reasonably in advance of the hearing date. This court also made a clear error by applying false facts, ones suggesting Adlife's complicity with Mr. Liebowitz, rather than the true facts showing Adlife's ignorance, to the law of sanctions, and in the process concluding erroneously that Adlife, rather than Mr. Liebowitz, should be punished. Mr. Liebowitz caused the harm to this court and Karns, not Adlife. Mr. Liebowitz should pay the price for his dilatory behavior. The true facts show that Mr. Liebowitz was responsible for the delays and failures to produce discovery. It was manifest error for this court to hold Adlife responsible. And upon correcting this error, the court should sanction Mr. Liebowitz to compensate Karns and make it whole. The court's memorandum dated February 23, 2021, filed at docket 59, recited certain matters as fact that are in truth not accurate concerning Adlife's awareness of the progress of the litigation in this case, Adlife's participation in the discovery process with its attorneys Richard Liebowitz and James Freeman, the progress of Adlife's litigation in other cases, the actions of Adlife's former counsel Richard Liebowitz and James Freeman taken on behalf of Adlife, the actions of Mr. Liebowitz taken on behalf of his other clients, and the sanctions levied against Mr. Liebowitz by federal courts around the country. The court appears to have mistakenly lumped Adlife in with Mr. Liebowitz, concluding that because Mr. Liebowitz is a legal lamprey, then so is Adlife. Because the defendant in this case called Adlife a sophisticated litigator of copyright disputes, and because a preliminary filing in an Adlife case that Mr. Liebowitz was not involved in referred to Adlife as a copyright troll in MyWebGrocer versus Adlife Marketing, this court appears to have assumed that Adlife was sophisticated in its own right about its litigation management, including its management of Mr. Liebowitz. That was one of the court's mistakes of fact. Adlife is not sophisticated in matters of litigation. Adlife has no in-house lawyer. And while Adlife does have an in-house paralegal, Rebecca Jones, Ms. Jones did not access Pacer or follow the progress of Mr. Leibowitz's handling of Adlife's cases online. Rather, Ms. Jones relied on weekly update calls from Mr. Liebowitz on Adlife's cases that he was handling, and Ms. Jones trusted Mr. Liebowitz to keep Adlife truthfully updated on what was happening with Adlife's cases. The true facts are that Mr. Liebowitz lied to Adlife, and Adlife did not know Mr. Liebowitz was lying. Filed with this motion are the declarations of Ms. Jones, Mr. Albrizio, Mr. Florent, all of Adlife. All three attest to their lack of knowledge regarding Mr. Liebowitz's record of sanctions and misbehavior in this case. All of Ms. Jones' status updates for the relevant period of time are attached to her declaration. All of Mr. Albrizio's and Florent's relevant correspondence are attached to their declarations. In addition, counsel for Adlife, using a respected and capable ESI consultant, I don't know, electronically stored information? I don't know what the ESI is. Harvested Adlife's emails for these three witnesses. So yes, electronically stored information. And searched them to confirm that what Adlife says is true. It is true. Confirmation was particularly important to the undersigned because Mr. Liebowitz's failure to notify Adlife of the decision in Usherson subjects him to potential criminal prosecution for perjury. That was because the court in Usherson, I think it was Judge Jesse Furman, had ordered Liebowitz to tell his clients about the judge's decision and serve a copy of the judge's decision upon them. So if he says to the court that he did that, and Adlife is now saying that he didn't do that, yeah, that could be some kind of lying to the court, a violation of his rules of professional conduct. A duty of candor and honesty to the tribunal is one of your rules of professional conduct. So his ethical rules of professional integrity. And it could also be perjury. The declarations of Ms. Jones, Mr. Albrizio, and Mr. Florent confirm that neither Mr. Liebowitz nor anyone else at the firm told Adlife that Adlife failed to produce discovery in this case. To the contrary, the declarations of Ms. Jones, Mr. Albrizio, and Mr. Florent confirm that Mr. Liebowitz and LLF's Mr. Freeman were provided with Adlife's discovery documents concerning the images at issue in this case, and Adlife's copyright registrations before this case was filed, and numerous times thereafter, that Mr. Liebowitz and LLF had all of Adlife's discovery information and documents while this case was pending, that whenever Mr. Liebowitz or Mr. Freeman requested documents or information from Adlife, Adlife immediately provided all of its information and documents to counsel, and that the Adlife parties had no reason to believe that Mr. Liebowitz, Mr. Freeman, or the firm were not managing the case until November 13th, 2020. This case was filed September 13th, 2019. Before the case was filed, Ms. Jones sent a PDF listing the 36 copyrighted images that Karns infringed a total of 89 times to Mr. Liebowitz, along with a link to a shared folder where all the documents supporting the claims could be found. On February 3rd, 2020, Mr. Liebowitz sent an email to Ms. Jones asking Karns would like a spreadsheet of the 22 different copyright registrations and the effective date of each. Can you kindly put this together? On February 21st, Liebowitz sent an email with written discovery requests. Ms. Jones reviewed the discovery requests. She discussed them with Mr. Freeman and told them that all the documents responsive to the discovery requests were provided before the case was filed. On February 26th, Liebowitz sent an email to Florent and Albrizio asking, can we get a total count to date of the number of photos used by Karns? Albrizio responded, we already have 59 images. That's a lot of images. On April 13th, 2020, Freeman of LLF sent an email to Jones that copied Liebowitz and attached a second set of discovery requests served by Karns. In that email, he asked for a telephone call with Jones. The call was held that afternoon with Jones, Albrizio, and Florent in attendance. Adlife provided Mr. Freeman with all the information he requested to respond to the discovery requests. If this sounds like it's tedious, it is. When you get discovery requests, there's a ton of back and forth to make sure that you fully complied with the discovery requests, because if you don't comply with them, there can be sanctions, there can be motions to the court, you can look bad before the judge. You really want to participate fully in the discovery process. The next day, April 14th, Donna Halprin, an employee of LLF, sent Mr. Albrizio interrogatory answers to sign, and he electronically signed them. Mr. Jones received no further updates until August, when Mr. Liebowitz sent an email, can you kindly gather all the copyright registrations for the Karns case? We need to proceed this Tuesday. Despite the short notice, Ms. Jones dropped what she was doing and resent Mr. Liebowitz, which you could also say resent Mr. Liebowitz, and Mr. Freeman the link to the Adlife shared folder containing all of the copyright registration certificates, which apparently was already there the whole time. This court then ruled that plaintiff must have become aware of its counsel's egregious history of misconduct after being served with the sanctions opinion and order of June 26th from the Southern District of New York in Usherson v. Banshell Artist Management, in which Mr. Liebowitz was sanctioned and ordered to serve a copy of that order either by email or overnight courier on every one of his firm's current clients, including Adlife. It appears that Mr. Liebowitz failed to serve Adlife with the Usherson decision, and then falsely certified that he served Adlife in the July 27, 2020 declaration Mr. Liebowitz filed in Usherson, in which he claimed to serve a copy of the order in Usherson on every one of LLF's clients. Misters Albrizio and Florent and Ms. Jones all carefully and diligently reviewed and searched their email for the period from June 26, 2020 to present, but none of them ever received an email from Mr. Liebowitz on July 27, 2020, or any other date, serving them with a decision in Usherson. Adlife's counsel independently confirmed this to be true by obtaining and reviewing all of Adlife's emails for Ms. Jones, Mr. Albrizio, and Florent. Mr. Liebowitz did not advise Adlife's paralegal about the decision in Buckingham Brothers when it came out in August of 2020. Ms. Jones found it on her own November 16th, 2020. Which one's Buckingham Brothers? I'll have to figure out what Buckingham Brothers was. Maybe we have to cover that case too. Before that date, the only thing Mr. Liebowitz told Ms. Jones about Buckingham Brothers was what she wrote in her status report about the case on August 21st, which was, Buckingham Market, Richard requested $30K in default. Judge questioned the amount, one image. Richard will write to the judge and reduce request to $10K. As a result, the primary contact for case updates with Mr. Liebowitz, the paralegal who had training and understood the import of the decision of Buckingham Brothers, did not have the decision in that case and did not know about Mr. Leibowitz's misconduct there until mid-November 2020. So yeah, it sounds like we have another Liebowitz case to look at. We'll bring that to you shortly, I guess. Mr. Liebowitz did not advise Adlife's CEO, Mr. Albrizio, of the Buckingham Brothers decision. Mr. Albrizio first learned about that decision from another one of Adlife's attorneys in a different law firm, who sent Mr. Albrizio a link to the article online about the decision. Let's take a look at this link. And here is TechDirt's reporting. Judge recommends copyright troll Richard Liebowitz be removed from role of the court for misconduct in default judgment case. This was from, okay, I know why we missed this one, because apparently this was from the end of August 2020, which was when Kaylee and I were reuniting and getting married, and that's probably why I missed it. We were on the shortest honeymoon that we don't think we had a honeymoon, basically. It was a very stressful second marriage. And so Mike Masnick writes that the court said basically that the judge sanctioned Liebowitz and recommended he be removed from the role of the court, and we will cover that then separately. Back to our story. Mr. Albrizio read the article and immediately emailed Mr. Liebowitz demanding a conversation, to which Liebowitz wrote back, yes, this was the case we discussed about. Terrible judge that didn't agree with the $30K in default. We often get $30K on default, but this judge is just devaluing copyright laws. Think we can ask the court for $10K. Mr. Albrizio then asked Mr. Liebowitz directly about the court's statements in which he names cases of Adlife. Mr. Albrizio knew at the time that all but one of the 5 Adlife cases referred to by the court in footnote 10 of the Buckingham Brothers decision had been dismissed because those matters settled, not because the filings in those cases were incorrect, as the court in Buckingham Brothers concluded. Mr. Florent, who was made aware of the Buckingham Brothers decision by Mr. Albrizio, also knew that the court in Buckingham Brothers must have been mistaken because the CFO of Adlife, Mr. Florent, was in charge of settlements, so he knew what cases settled, and all but one of the cases mentioned settled. This court also references numerous dismissals of its own cases referring to Adlife cases mentioned in footnote 10 of Buckingham Brothers. The court indicated that these dismissals should have put Adlife on notice of Mr. Leibowitz's misconduct. This court was mistaken in its assumption because those other cases were settled or dismissed for other reasons that did not indicate misconduct was committed by Mr. Liebowitz. Adlife Marketing versus Yoder's Meats was settled in June of 2020, and no one at Adlife was aware of any problems in that case. The Buckingham decision faulted Mr. Liebowitz for failing to serve a summons, but the case file shows that service was made on the defendant. Adlife v. Mussers was settled, and Mr. Liebowitz never advised Adlife of any issues in that case, nor did he ever tell anyone at Adlife that he was not admitted to practice in the district. The court's docket provides no indication of problems either. Adlife v. Tops Markets was settled in March of 2019 when a marketing company known as Pure Red came forward, indicated that it was the source of the images used by Tops Markets, and several other grocery chains took responsibility for the infringement and promptly settled with Adlife on behalf of Tops Market and other infringers. Adlife v. Walmart was one of several claims for infringement Adlife asserted against Walmart. The case was settled in March of 2019, and no one at Adlife knew anything about Mr. Leibowitz's failure to comply with the local rules of the District of Colorado. Mr. Liebowitz told Adlife that the Acme Markets case was dismissed because Mr. Liebowitz sued the wrong Acme Markets because Acme is a common corporate name. No one at Adlife had any information to indicate Mr. Liebowitz was lying. A copyright troll is a party, person, or company that enforces copyrights it owns for purposes of making money through litigation in a matter considered unduly aggressive or opportunistic, generally without producing or licensing the works it owns for paid distribution. Adlife is not a copyright troll. Adlife produced and licenses the works it owns. Founded originally by Joel Albrizio as an advertising and design agency, Adlife's photographers create hundreds of thousands of images of all varieties of fresh and prepared foods for use in advertisements and circulars Adlife creates for its food business clients. Every image in Adlife's preparedfoodphotos.com library was either photographed by Mr. Albrizio himself or created under his direct supervision. Today, Adlife is a full-service advertising agency. The vast majority of Adlife's revenue comes from print and digital advertising services and social media services. Adlife still produces color-printed grocery circulars. Adlife is one of only a handful of food image libraries in the world that can serve the needs of grocers and food wholesalers for images to feature in those circulars, because every image in Adlife's image library was painstakingly color corrected for optimal use in the 4-color printing process, CMYK. Printed color retail circulars continue to be critical to the success of Adlife's clients. So then they go into further information about how Adlife is a legit business, and I don't disagree. Then they go into how they are the victim of hundreds of infringements. The case of My Web Grocer v. Adlife is one example. Here, the infringer sued for declaratory judgment of non-infringement, but the infringer was a blatant infringer of Adlife's images online that Adlife notified was infringing. My Web Grocer accused Adlife of being a copyright troll. It is also true that My Web Grocer stole Adlife's copyrighted images and used them without permission or compensation to Adlife. Adlife counterclaimed for infringement and violations of the Vermont anti-SLAPP statute. The case was ultimately settled confidentially after significant litigation, including the unreported decision denying the parties' cross motions for summary judgment and sending the case to trial. By the time Karns filed its motion to dismiss for failure to prosecute, Mr. Liebowitz had towed Adlife 20 miles out to sea in a lifeboat with no provisions, and Adlife did not even know it. Adlife was in extremis, exactly the situation that the Third Circuit in Dunbar warned district courts about that required notice and a hearing before dismissal. Liebowitz did not care. This is obvious, even in his final communication to Adlife. Given the chance to come clean about what happened on November 15, 2020, Liebowitz cannot even overcome the conflict inherent in the situation to tell Adlife the whole truth, and instead he made crucial omissions to protect himself. Quote, "On the case against Karns months ago, they did a summary judgment on the issue that we did not provide proof of actual damages, and we are going for statutory damages, so you do not need to prove actual damages for a statutory case. So their motion will likely not succeed, and even if it does, you still have the $750 to $150,000 for statutory, willful infringement. Our response was put on pause as I needed to get a local lawyer in Harrisburg, which took some time to get. The judge did not set a time limit on when to get a local lawyer in Harrisburg. I thought the parties would do a mediation before having to get a local lawyer. Instead of trying to, in good faith, do a mediation, they did a motion for lack of prosecution, which has almost no shot of winning as the court never set a time limit to get a local lawyer. In any event, I got a local lawyer late last week to come in, and we responded to them and told the judge to require the other side to participate in mediation. The judge is likely going to set a status conference in the upcoming few weeks to talk about mediation and talk about new discovery deadlines. Karns never produced any documents in the case, so we have a strong argument that they have not engaged in good faith. The case is taking its course. Let me know if you want to jump on the phone to discuss more. Thank you, best Richard Liebowitz. Within 1 week after this email, Liebowitz was terminated by Adlife. So then they go into the motion for reconsideration standard governed by Rule 59E of the Federal Rules of Civil Procedure, which allows a party to move to alter or amend a judgment within 21 days. A judgment may be altered or amended on the following grounds. 1, an intervening change in controlling law. 2, the availability of new evidence that was not available when the court granted the motion. Or 3, the need to correct a clear error of law or fact to prevent a manifest injustice. A motion to alter or amend the judgment provides an opportunity for plaintiff to present its explanation of the delay. The court determined that in evaluating the history of plaintiff and Mr. Liebowitz's conduct in this case, as well as the relationship between Liebowitz and plaintiff in general, the court does not find that this is a case of an innocent client suffering the sanction of dismissal due to dilatory counsel whom it hired to represent it. However, there is no record evidence of Adlife's involvement or lack thereof, so this conclusion was conjectural and not based on the record. The true facts set forth in the declaration show that Adlife had no knowledge of Liebowitz's misconduct or control over it. This case is nothing like Adams, where delays by in-house counsel were to blame. Adlife has no in-house counsel. Adlife has a paralegal who relied on Mr. Liebowitz to keep it updated, and who diligently provided discovery to Mr. Liebowitz, and Mr. Liebowitz failed to produce. This is not the Adams case. This case is also different from cases where plaintiff bore responsibility for its attorney's misconduct because the plaintiff was personally sanctioned before, as in Comdine 1, or where the plaintiff was present at hearings concerning the attorney's misconduct in Curtis T. Bedwell and Sons versus International Fidelity Insurance Company. Faced with the increasing trend toward the dismissal of legal actions based on dereliction of duty by members of the bar, the Third Circuit has laid down the following requirements to protect clients dependent on their attorneys to protect their interests, because of the conflict of interest almost inherent in such a situation. Quote, from Dunbar, we conclude that any motion, whether by court or counsel, seeking an effective dismissal or default judgment based on an apparent default on the part of a litigant's counsel, be pleaded with particularity and with supporting material, and that where the papers demonstrate reasonable grounds for dismissal on that basis, the court shall direct the clerk of court to mail notice directly to the litigant of the time and place of a hearing on any such motion reasonably in advance of the hearing date. We are confident that district judges have the necessary remedies to prevent any abuse of this procedure. We think that such a procedure will put the client on notice of possible jeopardy to his or her legal interests by counsel's conduct at a time when the client can take appropriate action, and when the Paulus balance has not been irretrievably struck in favor of the moving party. Adlife was deprived of notice and a hearing. Adlife was dependent upon Mr. Liebowitz to keep Adlife informed, but Adlife had a conflict of interest with Mr. Liebowitz that Adlife did not know about and that Mr. Liebowitz hid from Adlife. Mr. Liebowitz kept Adlife in the dark. This court assumed Adlife knew what was going on, but Adlife did not, and at the very least, under Dunbar, Adlife was entitled to a pleading pled with particularity and notice of a hearing before dismissal could enter. The Third Circuit has identified 6 factors that a court should consider before dismissing an action for failure to prosecute. 1, the extent of the party's personal responsibility. 2, the prejudice to the adversary caused by failure to meet scheduling orders and respond to discovery. 3, a history of dilatoriness. 4, whether the conduct of the party or the attorney was willful or in bad faith. 5, the effectiveness of sanctions other than dismissal, which entails an analysis of alternative sanctions. And 6, the meritoriousness of the claim or defense. Adlife was not at fault. The true facts show that factors 1, 3, and 4 favor Adlife. Mr. Leibowitz's conduct was to blame, and had the true facts been known, would have compelled this court to sanction Mr. Liebowitz, which are more appropriate than the drastic sanction of dismissal. Changing Mr. Leibowitz's behavior is not relevant in the current dispute, where he has been terminated. Liebowitz is no longer Adlife's counsel, and the sanctionable conduct and delays in this case ended upon his termination. After Leibowitz's termination, Adlife and its current counsel, Sriplaw, actively prosecuted this case in good faith. The conduct and delays caused by Mr. Liebowitz will not continue. Meanwhile, any prejudice to Karns was slight. Karns had notice of its conduct that formed the basis of this action in the extensive exhibit to the complaint that identified all the images and uses. Any prejudice by delay can be cured by a brief discovery extension. Karns itself requested a 90-day extension of discovery in connection with its third-party complaint. Karns also admitted it failed to produce responsive discovery in this matter. Respectfully submitted, Joseph Dunn from Sriplaw. So I am sympathetic. That sounds an awful lot like they were kept in the dark, and I'm assuming that Mr. Leibowitz will maybe have a chance to respond to that. I don't actually know if he gets a chance to respond to that, but certainly the opposing party gets a chance to respond to that. And it sounds like Leibowitz was in a conflict of interest. His own personal and professional interests were in conflict with his clients. He would look bad if he told his clients that he had screwed up in his case. But I don't know if you remember, but a couple years ago, we showed what I think is a quintessential example of how you're supposed to handle that. A law firm in Pennsylvania had missed a deadline and a client had lost their case, and the law firm wrote to the client and said, "We messed up your case. We're sorry, but you now have a claim against us. And if you want to pursue the claim against us, here's how you can pursue the claim against us." And that's how you're supposed to do it. The lawyer is the fiduciary. The lawyer is supposed to have the client's best interests at heart. And so in terminating that representation, because they screwed up, they had to say, "We screwed up. Here's how you sue us." And I believe they had insurance there that would take over and pay the judgment if the person had won the case. And I'm assuming that all of that got settled at some point, or I didn't hear anything more about it, but sometimes we miss things. Anyway, let me know what you think of that latest Leibowitz shenaniganry there in the comments below. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, also on Floatplane and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern U.S. time. We are a community-supported legal education channel. We thank you for your support on patreon.com/ljfrench, sponsors.com/law, through Floatplane membership and YouTube membership. Thank you very much in the month of March to the following $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Andy, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Brandyn, Abel, Torpedan, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you to the $5 plus supporters. Everyone will be scrolling on the screen in front of me. You're on the fake LED panel behind me, which we're using as a substitute for now until I make a new one. I love you all. I'll see you in the videos that drop. Have a great week. Bye.
I'm not a cat.